Have you ever found yourself, caught in a really specific legal bind? Maybe it's something about your job conditions, say, if you're in public service.
Or perhaps a tax issue, something really complex that just feels impossible to figure out.
Exactly. And your first thought, naturally, might be the regular courts. You think, okay, high court, maybe lower courts. But you also think about the time it takes, the procedures.
Sometimes daunting procedures, definitely, and
Nor-
often considerable wait times.
But what if there's another way, a different path, one that's actually designed for speed and maybe even more importantly, for real focused expertise on exactly those kinds of tricky issues?
That's precisely the question that led to a pretty major evolution in India's justice system. It's about asking, well, can we create something tailored?
Instead of just, pushing every single case, no matter how specialized, through the same big funnel.
Exactly. Imagine a system that recognizes, okay, this dispute is different, it needs a different approach, a tailored solution.
Well, welcome everyone to a deep dive into a part of India's justice system that's often overlooked, I think, but incredibly vital: tribunals.
Mm.
We're definitely not talking about your typical courts here. We're talking about a whole network of specialized bodies.
Mm.
Each one is carefully designed to handle very specific kinds of disputes.
It's a fascinating area, quite complex, but really impactful. It touches a lot of lives, often without people even realizing it.
So today, for our deep dive, we're drawing heavily on a foundational text on Indian polity. It gives us a really solid, comprehensive overview.
And our mission really is to unpack where these tribunals came from constitutionally, look at how they actually work day to day, and understand the impact they've had on, well, streamlining justice in India.
We want to help you understand not just what they are, but how they function. And maybe we'll uncover some surprising facts or key moments that have shaped their role today.
Hopefully, yes.
And by the end of this deep dive, we hope you'll have more than just a definition. You'll have, hopefully, a richer appreciation for why they matter so much, especially if you're trying to navigate the complexities of modern government and how disputes get resolved in India.
It's not just about legal structures, is it? It's fundamentally about making justice accessible and effective.
That's the core of it.
It really is. It's about designing a legal and administrative system that can actually cope, that can work effectively with the specific challenges that pop up in a country as diverse and, frankly, as rapidly changing as India.
And finding that balance, right, between needing speed and efficiency, but also needing absolute fairness and, crucially, that expert judgment.
That balancing act is key.
Okay, so let's start this exploration right at the beginning. Let's trace where these tribunals came from, their constitutional roots, to really get why they're important, maybe try to picture a time before they existed.
Go back in time a bit.
Yeah. Imagine a scenario where every single legal fight, no matter how niche, how technical, maybe a public servant's issue with their job conditions, or a super detailed tax assessment, or a complex labor dispute,
Everything
landed in the lap of the same civil courts and high courts, which were already, let's be honest, pretty overloaded.
Oh, absolutely.
What kind of problems do you think that would create for the system and for the people needing justice? I mean, the first thing that jumps to my mind is just waiting. An impossible backlog.
You're absolutely right to focus on that backlog because the challenges weren't just theoretical. They were very, very real. Before tribunals, the traditional courts, the civil courts, the high courts, they were just swamped with this incredible variety of cases.
Everything thrown at them.
Everything. And this led to some major problems. First, as you said, the colossal backlog. Cases could just sit there for years, sometimes decades even.
Decades. Wow.
Yes, and you know the saying, justice delayed is justice denied.
Yeah,
It really felt like that for many people.
I can imagine. If you're waiting for a promotion dispute or your company needs a tax clarification, these delays aren't just abstract legal waiting, are they?
Not at all. They translate into real financial stress, personal anxiety, uncertainty. It's not just inconvenient, it's actively harmful.
So it wasn't just the sheer number of cases, the quantity. There must have been a quality issue, too.
Precisely. That's the second equally critical point. The lack of specialized knowledge. Think about it. A judge in a regular court, they're incredibly skilled in general law, no doubt.
Sure.
But would they necessarily have that deep, intricate understanding needed for, say, super technical tax codes, or complex environmental regulations, or the very specific, often quite arcane rules about public service employment?
Probably not, right? They can't be experts in everything.
Exactly. So this could lead to judgments that were maybe less efficient, perhaps less consistent, maybe even in some cases less accurate in these specialized areas, simply because the court wasn't equipped with that specific domain expertise. It's like asking a GP to perform highly specialized brain surgery. They're both doctors, but different skill sets.
So the pressure on the traditional judges must have been immense, and the need for something else, some alternative, must have become really obvious.
Undeniable. The practical need for alternative ways to resolve disputes wasn't just a nice idea, it was urgent. Tribunals emerged as this strategic solution, a way to take some pressure off the main courts and, importantly, inject that focused expertise where it was needed most.
A kind of specialized relief valve for the justice system.
You could put it that way, yes.
Yeah.
It was a big step towards modernizing the whole judicial setup to deal with the growing complexity of, well, running a modern state.
And that brings us right to a really pivotal moment in India's constitutional story. The 42nd Amendment Act of 1976. Now, for listeners who might not know, the original Constitution, as it was first written, it didn't actually mention tribunals specifically, did it?
No, it didn't, which makes this amendment so significant. It wasn't just a minor tweak, it was a landmark change. It literally added a whole new section, Part 40A, to the Constitution, specifically titled Tribunals.
So it wasn't just a law passed by Parliament, it was written into the Constitution itself.
Exactly. And that's crucial. It formally embedded the whole concept of tribunals within the constitutional framework. This wasn't just a temporary fix. It was a signal of a fundamental shift in how certain kinds of disputes were going to be handled from then on.
A recognition that the old system needed help.
A recognition that the traditional court structure, while absolutely essential, needed specialized partners, if you like, to manage the growing caseload and the increasing technicality of disputes, especially those involving the government and its agencies.
Now, we're not going to get sidetracked into the whole political context of the 42nd Amendment. That was certainly an era of significant constitutional changes, some quite controversial.
Indeed, a complex period.
But putting the politics aside, it's undeniable that this particular amendment had a huge lasting impact on the judicial landscape. It fundamentally changed the architecture of dispute resolution in India.
It really did. It laid the constitutional foundation for a kind of parallel track for justice, especially for specific administrative and regulatory issues. This structural shift meant certain types of cases, particularly those needing technical know-how or a quick resolution, could go straight to a body set up specifically for that purpose.
Bypassing the general courts, at least initially?
In theory, yes. The aim was faster, more consistent, and hopefully more informed decisions. That was the pressing need.
Okay, now here's where it gets really interesting, because it shows the specific design thinking behind this new system. This 42nd Amendment didn't just say, let there be tribunals. It set up two distinct pillars, Article 323A and Article 323B.
Ah, yes, the twin pillars. Absolutely fundamental.
Let's unpack this a bit. Article 323A, that one deals specifically with administrative tribunals. And Article 323B, that seems to cover tribunals for a whole bunch of other things, right? Broadening the scope quite a bit.
That's the core distinction, yes. Those two articles are truly the bedrock of the whole system. Article 323A is very focused. It gives Parliament the power, only Parliament, actually, to set up administrative tribunals just for disputes about recruitment and conditions of service for people in public services.
So government employees, basically. Center, states, local bodies, public corporations.
All of that, yes. It's a huge area. Then Article 323B, that's much broader. It allows both Parliament and state legislatures to create tribunals for a whole list of other specific things: taxation, industrial disputes, land reforms, even food supplies.
Okay, so two different routes, two different scopes. We definitely need to dig into both. Let's start with that first pillar then. Administrative tribunals under Article 323A. The purpose, as you said, was very specific. Parliament could set up these tribunals just for disputes about recruitment and conditions of service of persons appointed to public services. That's a massive group of people. Center, states, local bodies, public corporations, other public authorities, basically anyone working for the government in some capacity.
And the intention behind it was very clear, very practical. It was, and I'm quoting roughly here, to take out the adjudication of disputes relating to service matters from the civil courts and the high courts and place it before the administrative tribunals.
Why? What was the driving force behind taking them out of the regular courts?
Think about the sheer volume of issues that crop up in managing a workforce as vast as India's public services.
Yeah.
Every promotion, every transfer, disciplinary actions, recruitment challenges, pension issues.
Right. Endless potential disputes.
Endless. And these would otherwise just flood the traditional courts, making that backlog problem even worse. So the benefits were seen as, well, firstly, speedy justice for public servants who felt aggrieved, and secondly, inexpensive justice, getting them out of the lengthy, often very costly and frankly emotionally draining court processes.
Providing a dedicated forum tailored for them.
Exactly, a specialized place for a specific class of disputes.
So Parliament got this power under Article 323A, and they didn't waste much time, did they? They acted on it fairly quickly with the Administrative Tribunals Act in 1985.
Yes, that act was the crucial next step. It turned the constitutional idea into a concrete reality. It authorized the central government to establish the Central Administrative Tribunal, the CT, and also state administrative tribunals, or SATs.
So the CT is the big one at the central level, and SATs are for the states.
Correct. And this 1985 act, it wasn't just ticking a box. It genuinely opened a new chapter, as the text says, in providing faster, cheaper justice for public servants.
How so? What was the real change on the ground?
Before this act, a government employee with a grievance often faced a really tough legal fight in the regular civil courts. Those courts, as we discussed, often lacked that deep specialized understanding of all the government rules, the departmental procedures, the service conditions.
The nitty-gritty stuff.
Precisely. This act created a dedicated forum, staffed by people who did understand that stuff, designed to quickly grasp and address their specific concerns. It was a significant leap forward in what we call administrative justice.
And the most prominent example, the one most people might have heard of, is the Central Administrative Tribunal, the CAT, set up in 1985, right after the act.
That's the main one, yes.
Its main office, the principal bench, is in New Delhi, which makes sense. But it obviously can't just be in Delhi, can it? It has to serve central government employees all over India.
Oh, absolutely not. It has a very wide reach, precisely to make it accessible. Currently, it operates through 19 regular benches spread across the country.
19. Okay, that's quite a few.
And interestingly, 17 of those benches are located at the main seats of the high courts. This is quite strategic. It makes them accessible in major judicial centers and uses existing legal infrastructure hubs.
Makes sense. And the other two?
The other two are in Jaipur and Lucknow, covering other significant administrative regions. But it doesn't stop there. To really extend their reach, especially to places that don't have a full bench, these benches also hold circuit sittings in other high court locations.
Circuit sittings, what does that mean exactly?
It means the judges from a main bench travel to another location periodically to hear cases there. So, for example, the Allahabad bench might travel to Nainital to hold sittings. The Guwahati bench covers places like Shillong, Imphal, Aizawl through circuit sittings.
Ah, okay. So they travel to the people, in a way, a very practical method to improve access without needing permanent buildings everywhere.
Exactly. It's a pragmatic approach to reach the public servants who need the service.
And the jurisdiction of these benches is geographically defined, too, right? Like the Madras bench covers Tamil Nadu and Puducherry.
Yes, precisely. The source material lists these out. The Bombay bench covers Maharashtra, Goa, Dadra, and Nagar Haveli, and Daman and Diu. They have clear territorial boundaries to manage the caseload effectively.
And what kind of cases do they actually handle? What falls under their original jurisdiction?
Their scope within their domain is very broad. The CCAT deals with recruitment and all service matters for public servants under its purview.
All service matters. That sounds comprehensive.
It is. It covers the All India services, IAS, IPS, IFS, the Central Civil Services, civil posts under the center, and, importantly, civilian employees working in defense services.
Civilian employees in defense, okay. Not the soldiers themselves, but the civilians working alongside them.
Correct. So this means issues related to pay, allowances, promotions, disciplinary actions, seniority disputes, transfers, retirement benefits, pensions, pretty much anything related to the terms and conditions of employment for these millions of central government employees falls under the CKD's jurisdiction.
But, and this seems important, there are specific groups who are excluded, right? It doesn't cover absolutely everyone connected to the government.
That's a crucial point, yes. The exclusions tell us something about the design. The CAT's jurisdiction deliberately does not cover members of the actual defense forces, the Army, Navy, Air Force personnel.
Why is that?
They have their own distinct system under military law, and significantly, the Armed Forces Tribunal, which is specifically designed for their unique service conditions and disciplinary needs.
Okay, so a separate specialized track for them. Who else is excluded?
Also excluded are the officers and servants working directly for the Supreme Court and the secretarial staff of Parliament.
And the thinking there?
It largely comes down to the principle of separation of powers, keeping the internal administration of the judiciary and the legislature separate from a tribunal established by the executive helps maintain their constitutional independence and autonomy. It avoids potential conflicts of interest and reinforces those essential checks and balances.
Right, ensuring those core institutions manage their own internal affairs. That makes sense. Okay, let's talk about who sits on the CIT. It's a multi-member body, a chairman and members. Has it always been like that?
Not quite. There was a slight evolution. Originally, the structure included a chairman, vice chairman, and members, but an amendment in 2006, the Administrative Tribunals Amendment Act, removed the position of vice chairman.
Ah, okay. So now it's just a chairman and members. How many are there?
The current sanction strength reflects the workload. It's one chairman and 69 members.
69 members. That's a significant number.
It is. And what's really beneficial about the composition is who these members are. They're drawn from both the judicial stream and the administrative stream.
Judicial and administrative. So judges and former civil servants.
Essentially, yes. People with judicial experience, perhaps former high court judges, and people with extensive administrative experience, like senior retired civil servants. This blend is incredibly valuable for service matters.
How so? What does each side bring?
Well, the administrative members bring that deep, practical understanding of how government actually works. The internal policies, the hierarchies, the feasibility of implementing certain orders, they know the system from the inside. The judicial members ensure legal correctness, adherence to principles of natural justice, due process, and understanding of precedents and law.
So you get both legal framework and the practical reality checks. Sounds like a good mix for making sensible decisions in complex service disputes.
It leads to more effective, realistic, and legally sound judgments, yes.
And what about their qualifications? How old do they have to be? How long do they serve?
To ensure they bring substantial experience, there's a minimum age requirement. You have to be at least 50 years old to be appointed as chairman or a member.
Okay, so seasoned professionals.
Definitely. And their tenure, according to the Tribunals Reforms Act of 2021, which shows the system is still being updated, is for 4 years, or until they reach a certain age, whichever comes first. For the chairman, the age limit is 70, and for members, it's 67.
4 years. That seems relatively short.
It's a point that has been discussed, yes. The tenure has been subject to changes over time through various reforms. The 2021 Act set it at 4 years.
Interesting. And the appointment process itself. How are these members and the chairman actually chosen? It seems like there's significant judicial involvement, which sounds important for independence.
Absolutely critical, yes. The appointments were formally made by the central government, but, and this is the key part, they are based on recommendations from a very high-powered search-cum-selection committee.
And who leads this committee?
This committee is chaired by none other than the Chief Justice of India, or a sitting Supreme Court judge nominated by the CJI.
Wow, the Chief Justice themselves or their nominee. That's serious oversight.
It signals the seriousness and the absolute necessity of judicial oversight in these appointments. It's designed to ensure impartiality, legal competence, and credibility in the selection process. It strongly reinforces the quasi-judicial nature and independence of the CAT, even though it's technically established by the executive branch.
That's a really powerful check and balance built into the system. Okay, now let's shift perspective to the applicants, the public servants seeking justice. What's the process like for them? Is it like a full-blown court case, very formal and rigid?
Not at all, and this is a key advantage. The CIT is specifically not bound by the strict rules of procedure laid down in the Civil Procedure Code of 1908, which governs the regular civil courts.
So less red tape.
Considerably less.
Yeah.
Instead, it's guided by the principles of natural justice. This is a fundamental concept in administrative law, basically meaning fairness. Decisions must be fair, people must get a chance to be heard, the decision maker shouldn't be biased.
What does that mean in practice for someone filing a case?
It means the process is generally more flexible, less formal, and quicker. Natural justice ensures things like you have the right to present your side of the story, you have the right to know the case against you, and the person deciding shouldn't have a personal stake in the outcome. This flexibility makes the CCAT less intimidating and more user-friendly, especially for individuals who might not be familiar with complex legal procedures.
And the cost. You mentioned inexpensive justice earlier. How affordable is it, really?
Remarkably affordable. To file an application, you only need to pay a nominal fee of
50 rupees? That's incredibly low.
It is, and the significance of that low fee for access to justice is huge. It means financial constraints shouldn't stop an aggrieved public servant from seeking redress. It really opens the door.
That's genuinely accessible. And do they need a lawyer?
They have a choice. Applicants can appear in person and argue their own case if they feel comfortable doing so, or they can hire a lawyer. It offers both autonomy and the option of professional representation.
Okay, flexibility, low-cost choice. Sounds designed to be approachable. Now, here's a point that sounds really crucial, the relationship between the CIT and the high courts. Originally, things were quite different regarding appeals, weren't they?
Very different, and it led to a major constitutional challenge. Initially, the act stated that appeals against CIT orders could only go directly to the Supreme Court,
Skipping the high courts entirely.
completely bypassing them, which, as you can imagine, was controversial, given the High Court's traditional powers of judicial review over administrative actions.
So what happened?
Well, this setup was challenged, and it reached the Supreme Court in a landmark case. L. Chandra Kumar versus Union of India, decided in 1997.
L. Chandra Kumar, 1997. Okay, what did the Supreme Court say?
The court delivered a really profound verdict. It declared that this restriction, excluding the High Court's jurisdiction, was unconstitutional.
Unconstitutional. Wow, that's a strong statement.
It was a pivotal moment, fundamentally reshaping the tribunal system's place within the overall judicial structure.
What was the reasoning? Why did they strike it down?
The core reasoning rested on a fundamental principle of Indian constitutional law, the basic structure doctrine.
Ah, the basic structure doctrine. That's the idea that certain fundamental features of the Constitution can't be amended away, right?
Exactly. The Supreme Court held very firmly that judicial review, the power of the courts, especially the high courts under Article 226 and the Supreme Court under Article 32, to review the actions of the state is an integral part of the basic structure of the Constitution.
So Parliament can amend the Constitution, but it can't touch these core features.
Precisely. And the power of judicial review is considered one of those untouchable core features. By creating a system where tribunal orders bypass the high courts, effectively removing a key layer of judicial oversight, the original act was seen as damaging this basic structure.
So what's the situation now? After the Chandra Kumar ruling, where do appeals from the CIT go?
The ruling meant a significant change. Now, appeals against CIT orders must first go to the division bench that's typically 2 judges of the concerned high court.
So the high courts are back in the picture.
Firmly back in. Only after you've gone through the high court route can a party then potentially appeal further to the Supreme Court.
What are the implications of that? Why is that important?
It has huge implications. Firstly, it ensures a multi-tiered review process. You get scrutiny from the specialized tribunal, then scrutiny from the high court before it even gets near the Supreme Court. This provides more checks and balances. Secondly, it reinforces the vital role of the high courts as constitutional courts with broad powers of review. And thirdly, it protects citizens' rights by offering a more accessible appellate forum. The high court is often geographically closer and perhaps procedurally more familiar than going straight to Delhi for the Supreme Court.
It sounds like a crucial rebalancing act, ensuring efficiency doesn't override fundamental judicial oversight.
Exactly. It embeds the tribunals within the judicial hierarchy rather than letting them operate as completely separate islands.
And the 1985 Act didn't just create the CAT, right? It also paved the way for state administrative tribunals, the SATs.
Yes, that's correct. The same act empowers the central government to establish SATs, but only upon a specific request of the concerned state governments.
So states have to ask for them.
Yes. If a state feels the need, it can request the center to set up an SAT. These SATs then exercise similar original jurisdiction dealing with recruitment and service matters, but specifically for the employees of that particular state government.
Same goal then. Speedy, inexpensive justice, but for state employees.
Precisely. They function as the state-level equivalent of the SAT.
And the appointment process for SATs, does it mirror the SATs process with that judicial oversight?
It does, but with a logical adaptation for the state level. The chairman and members of an SAT are appointed by the central government, again based on recommendations from a search-cum-selection committee. But for the SATs, this committee is chaired by the Chief Justice of the High Court of that specific state.
Ah, so the state's top judge is involved.
Yes, ensuring state judicial leadership oversees the selection for the state-level tribunal. It maintains that crucial judicial involvement and oversight tailored to the state context.
And the Act even allows for something called a Joint Administrative Tribunal, a JAT. What's that about?
That's another practical provision. The Act allows for setting up a single Joint Administrative Tribunal, JAT, to serve 2 or more states if they agree.
Why would they do that?
It can be very beneficial, especially for smaller states or maybe states with similar administrative setups or smaller numbers of employees, where setting up a whole separate SAT might not be cost-effective or necessary. A JAT exercises the same powers as an SAT, but covers multiple states.
So, pooling resources.
Exactly. Resource sharing, efficiency gains, potentially more consistent application of law across states with shared interests or employee groups. It's about optimizing resources while still providing that specialized forum.
That makes a lot of sense, ensuring the system can scale appropriately. Okay, so we've covered Article 323A and the administrative tribunals CAT, SATs, JATs quite thoroughly. Now let's broaden out significantly and look at Section 3. Tribunals for other matters under Article 323B. This is where specialized justice really branches out, isn't it?
It really does. This is where the concept spreads beyond just public service disputes and permeates various other critical areas of the economy and society. Under Article 323B, the power to establish tribunals is given to both Parliament and state legislatures for a whole range of other specific types of disputes.
Both Parliament and the states. That's a key difference already from 323A, where it was just Parliament.
A very important difference, yes. It reflects the division of powers in the Constitution.
And the range of topics under 323B is incredibly diverse. It's not just one theme like service matters. The source lists things like taxation.
Yes, taxation is a major one. Think Income Tax Appellate Tribunal, ITIT.
Foreign exchange, import, export. Very technical.
Highly technical, yes. Requires specific financial and legal knowledge.
Industrial and labor disputes. Crucial for the economy.
Absolutely. Often needing quick resolution. Things like the National Company Law Tribunal, NCLT, handle complex corporate matters too.
Land reforms, ceiling on urban property. These sound like state-level issues often.
Frequently, yes, which links back to why state legislatures can also create tribunals under 323B.
Elections to parliament and state legislatures. Wow, even electoral disputes.
Yes, though the practical implementation and interaction with election commission and courts is complex there.
Foodstuffs.
Yeah.
And rent and tenancy rights you mentioned that was added later.
Yes, rent and tenancy rights were added by the 75th Amendment in 1993. This shows the system isn't static. It evolves as new needs for specialized adjudication are identified. We also see things like the National Green Tribunal, NGT, dealing with environmental matters falling under this broader umbrella.
What's really fascinating here is thinking about why these specific areas benefit from tribunals. Take tax, for example.
Tax law is notoriously complex, right? It's constantly changing, full of intricate rules, accounting principles. Having a dedicated tribunal like ITAT, staffed with members who are experts in finance, accounting, and tax law, means they can understand the nuances and resolve disputes much more effectively and hopefully accurately than a general court judge who deals with everything from property law to criminal cases.
They speak the language, basically.
Exactly. Same for environmental cases before the NGT. These often involve complex scientific evidence, ecological principles. You need people with that specific background to make informed decisions. Or think about corporate insolvency under the NCLT requires deep understanding of business, finance, company law.
So it's really about matching the complexity of the subject matter with specialized expertise in the decision makers.
That's the core idea. Speed is a factor, yes, but so is the quality and appropriateness of the decision-making.
Okay, let's really nail down the differences. We've touched on them, but comparing Article 323A and 323B side by side seems important to understand the design. They're both about tribunals, but they have these crucial differences.
Absolutely. Understanding these distinctions is key to seeing the logic behind the system.
So, difference number one, the scope of matters.
Right. 323A is exclusive to public service matters, narrow focus. 323B covers that list of other specific areas, tax, labor, land, environment, etc. Broader, but still defined subjects.
Got it. Difference number two, who can set them up?
The establishing authority. Under 323A, only Parliament can create administrative tribunals. Reflects the often central nature of the services involved. Under 323B, both Parliament and state legislatures can create tribunals, but only for matters that fall within their respective legislative powers.
Which makes sense for things like land or rent, which are often state subjects.
Exactly. It allows for decentralized specialization where appropriate, according to the constitutional division of powers.
And the third difference, which sounded quite structural, hierarchy.
Yes, hierarchy. Under 323A, administrative tribunals, the structure is generally flat. You have the CAT or the SAT, maybe a JAT. There's usually no appeal within the tribunal system itself. You go there, and then the next step, post Chandra Kumar, is the High Court.
Okay, a single specialized stop.
Largely, yes. But under Article 323b, the provision explicitly allows for a hierarchy of tribunals to be created.
What does that mean in practice? Multiple levels of tribunals?
It can, yes. Take tax again. You might have initial adjudication, then an appeal to a body like the ITAT, perhaps even further levels within the specialized system in some cases before you get to the high court. This allows for multiple layers of specialized review within that specific domain, potentially resolving more issues before they even hit the regular court system.
Building a deeper specialization pathway within fields like tax or environment.
Precisely. It allows for a more tiered structure tailored to the needs of that specific subject area.
And just to be absolutely clear, the Chandrakumar ruling about judicial review, ensuring appeals go to the high court, that applies to these 323B tribunals too, right? They didn't escape that.
Absolutely not. The Chandrakumar judgment was comprehensive. It struck down the exclusion of high court jurisdiction for both Article 323A and Article 323B tribunals.
So no tribunal operates outside the high court's oversight.
Correct. The Supreme Court made it clear. Judicial review by the high courts and ultimately the Supreme Court is fundamental and applies across the board. So, judicial remedies are available against the orders of these other matter tribunals as well, via the high courts first. It's a universal principle reinforcing judicial oversight.
Okay, that's a vital safeguard across the entire system. Right, so we've covered a lot of ground. From the constitutional beginnings, the need for specialization, the two main types under 323A and 323B, the key features, the structures like CIT and SATs, and that crucial Chandrakumar case reshaping judicial review. Now let's bring it all together, the so what section. What's the real impact? Why is this important for you, the listener?
Well, stepping back, the main goals, the overarching purpose, remain pretty clear. Tribunals aim to provide speedy, inexpensive, and specialized justice.
Speed, cost, expertise. The big three.
And flexibility too, remember. They're guided by natural justice, not rigid codes, which helps achieve those goals.
And connecting those benefits to the real world.
Yeah.
What's the impact? How does it actually help?
Well, firstly, it significantly eases the burden on the regular courts. Think of all those cases they don't have to hear now. This allows high courts and the Supreme Court to focus on other critical legal areas, like major constitutional questions or complex criminal appeals.
So it helps the whole system function better.
Definitely. And for citizens, it means, hopefully, much faster resolution.
Wow.
A public servant gets their promotion issues sorted quicker. A business gets clarity on a tax dispute sooner. That reduces stress, uncertainty, and cost for individuals and companies.
And you get decisions made by people who actually understand the specific field, right?
That specialized expertise is key. It should lead to more informed, more consistent, and ultimately fairer outcomes in these technical areas. It's about making the justice system more responsive and tailored to modern complexities.
And thinking about streamlining justice, these tribunals really act as a crucial filter, don't they? Taking on this huge volume of specialized cases that would otherwise just overwhelm the higher courts.
They are absolutely essential filters. Without them, the existing court system would likely grind to a halt, frankly. They handle a massive number of cases, preventing the backlogs in the high courts and Supreme Court from becoming completely unmanageable. It's a strategic division of labor within the justice system.
So even if you, listening now, aren't a public servant or involved in a tax dispute or an environmental case, why should you care about Indian tribunals?
Well, understanding this layer is crucial for understanding how modern government actually works, how services are regulated, how disputes involving the state or specific sectors are handled. It's part of the machinery of governance.
And does a better tribunal system have broader benefits?
Oh, absolutely. A more efficient, specialized justice system strengthens the rule of law overall. When disputes are resolved fairly and promptly, it builds public confidence in institutions. Faster resolution of tax or commercial disputes boosts economic stability and certainty, which is good for everyone. Ultimately, it contributes to public trust when people feel justice is accessible and effective, even in complex areas.
Though it's probably not perfect, right? Are there ongoing challenges?
Of course. Like any large system, there are challenges. Sometimes there are delays in appointing members to tribunals, which can create backlogs within the tribunals themselves. Infrastructure can be an issue in some places, and there's always an ongoing discussion about ensuring their independence while maintaining accountability. These are real issues the system grapples with.
And finally, that dynamic balance we talked about. The Chandrakumar case really stands out, doesn't it? The Supreme Court stepping in to ensure high court oversight.
It's fascinating, yes. It highlights this constant tension, this dialogue between efficiency, the initial idea of perhaps limiting appeals, and the fundamental right to robust judicial review. It shows the system correcting itself, prioritizing constitutional safeguards.
So it's not just about being fast, it's about being just and accountable within the constitutional framework.
Precisely. It's a testament to the idea of a living constitution, where the judiciary plays that vital role in interpretation and protection. The initial design aimed for maximum efficiency, maybe even cutting a corner on appeals, but the court stepped in to say, no, judicial review is fundamental. It ensures that even as we innovate for speed and specialization, we don't lose sight of core principles of justice and oversight.
It's about being both agile and accountable.
That captures it perfectly.
Well, what a journey that was. We've really unpacked a critical, though maybe sometimes hidden, part of India's legal and administrative world. We went from the constitutional roots in the 42nd Amendment,
Driven by that need for specialization,
explored the two main branches, Article 323A for administrative matters and 323B for others. Looked at specific examples like the CAT-T, IT-AT, NGT,
and dissected their structure, procedures, and importantly, the appointment processes.
and crucially, discussed that landmark Andrew Kumar case and its impact on cementing judicial review over all tribunals.
It really shows these aren't just side bodies. They're an integral, evolving part of how justice is delivered in India today.
Definitely. And as we've seen, the whole idea of tribunals reflects this ongoing effort to adapt the justice system to the growing complexities of modern government. So, thinking about all this, what does the rise of these specialized bodies suggest about the future of legal systems, not just in India, but maybe everywhere?
It certainly suggests that specialization is becoming increasingly necessary as society gets more complex.
And where do you think the next frontier for specialized justice might pop up? Could we see tribunals for things like, I don't know, disputes over artificial intelligence, or maybe deep space resource rights, or complex climate change liability cases?
Those are fascinating possibilities. As technology, globalization, and environmental challenges create entirely new kinds of disputes, it seems almost inevitable that we'll need new, highly specialized ways to resolve them fairly and efficiently. The Indian tribunal experience, with all its successes and challenges, certainly offers valuable lessons for how legal systems might adapt.
It really does. So perhaps take some time to reflect on how these insights might reshape your own understanding of what justice means, how efficiency fits in, and how the rule of law keeps evolving in our incredibly complex world.